our business today is the Defence Forces Evidence Bill 2019. We have convened to consider the committee stage of the Defence Forces Evidence Bill 2020, which was referred to this committee back on the 23rd of September last. I welcome Minister for Defence, Minister Coveney and his officials, and I suggest that it is a lengthy bill. I suggest that we commence. Minister, Section 1, that Section 1 stand part of the bill. Agreed? Agreed. Section 2, that Section 2 stand part of the bill. Agreed? Agreed. Section 3, that Section 3 stand part of the bill. Agreed. Section 4, that Section 4 stand part of the bill. Agreed. Section 5, that Section 5 stand part of the bill. Agreed. Agreed. Section 6, that Section 6 stand part of the bill. Agreed. Agreed. Section 7, that Section 7 stand part of the bill. Agreed. Agreed. Section 8, that Section 8 stand part of the bill. Agreed. Agreed. Section 9, that Section 9 stand part of the bill. Agreed. Section 10, that Section 10 stand part of the bill. Agreed. Agreed. Section 11, that Section 11 stand part of the bill. Agreed. Section 12, that Section 12 stand part of the bill. Agreed. Section 13, that Section 13 stand part of the bill. Agreed. Section 14, that Section 14 stand part of the bill. Agreed. Section 15, that Section 15 stand part of the bill. Agreed. Section 16, that Section 16 stand part of the bill. Agreed. Agreed. Section 17, that Section 17 stand part of the bill. Agreed. Section 18, that Section 18 stand part of the bill. Agreed. Section 19, that Section 19 stand part of the bill. Agreed. Section 20, that Section 20 stand part of the bill. Agreed. Section 21, that Section 21 stand part of the bill. Agreed. Agreed. Section 22, that Section 22 stand part of the bill. Agreed. Section 23, that Section 23 stand part of the bill. Agreed. Section 24, that Section 24 stand part of the bill. Agreed. Section 25, that Section 25 stand part of the bill. Agreed. Section 26, that the amendment be made. Minister, Ara. Amendment number 1.
Yeah. Great. Can I just say in relation to the amendments, they're all technical amendments. There were no objections at second stage of this bill, but we have, I think, 6 technical amendments. Some of them are clubbed together. They're all recommendations coming from the Parliamentary Draftsperson's Office and the Parliamentary Council. But I'll go through each of them in turn. This is the first amendment, which is amendment number 1 on section 26. This is a drafting technical amendment which is being brought forward following a review of the current wording of this section of the bill by the Parliamentary Council. The amendment clarifies the purpose for which the DNA military police database system may be used. The amendment ensures that the wording of this section is consistent with provisions elsewhere in legislation, in other words, how the Gardaí do things. As provided for in the amendment, the DNA military police database system may be used for the following purposes. A, the investigation and prosecution of an offence against military law. B, to facilitate the DNA database system oversight committee to carry out its function. The functions of this committee, which was established under the Criminal Justice Forensic Evidence and DNA Database System Act 2014, will be extended under Section 83 of this bill to enable the committee to oversee the operation of the new DNA military police system. C, to facilitate the state's obligations under the Prum Council decision in relation to the automated searching and comparison of DNA profiles held in the DNA military police system on foot of requests from other states. Part 11 of the bill includes the detailed provisions concerning this matter. So in summary, this is a drafting amendment which has been recommended by the Parliamentary Council to ensure that there is consistency between the wording of this section and the bill as a whole.
Okay, thank you, Minister.
That's the amendment.
Any members wishing to offer? I take it that we can now proceed. Minister, did the amendment be made? Agreed? Agreed. That section 26 as amended stand part of the bill. Agreed? Agreed. Section 27, that section 27 stand part of the bill. Agreed. Section 28, that's Section 28 stand part of the bill. Agreed. Section 29, that's Section 29 stand part of the bill. Agreed. Section 30, that's Section 30 stand part of the bill. Agreed. Section 31, that's Section 31 stand part of the bill. Agreed. Section 32, number of amendments. 2 to 4 inclusive are related and will be discussed together. Minister.
I move the amendments number 2, 3 and 4. So if you look at page 31 of the bill, this is effectively adding some new wording in subsection 3. So amendment number 2, 3 and 4 are linked. Section 32, which is about permitted searching, sets out the manner in which a DNA profile entered into the DNA military police database system may be compared with other DNA profiles entered into that system and onto the DNA database system established under the Act of 2014. In other words, the work of Garda Síochána primarily. This series of amendments clarifies that DNA profiles entered in the reference military police index of the DNA database established under this legislation may be compared with DNA profiles held under the equivalent crime scene index and the reference index of the DNA database established under the Criminal Justice Forensic Evidence and DNA Database System Act 2014. The amendments arose following a concern raised by Forensic Science Ireland, or FSI as they're called, concerning the current wording of this section. FSI is responsible for establishing and operating the DNA database under both this legislation and the Act of 2014. Having reviewed the matter, Parliamentary Council has advised that an amendment to this section should be brought forward to clarify the matter and to ensure that the appropriate searches and comparisons can be carried out by the FSI in relation to DNA profiles held on the military police database and DNA profiles held on the database established under the Act of 2014. So I think that's self-explanatory. This is about trying to make sure that the two databases can be cross-referenced, essentially, if there are cases that justify that. So these three amendments, Amendment 4 is the most important of them. The other is just facilitating Amendment 4, effectively 2 and 3, in terms of change of wording. But I think it's a sensible amendment, and I hope you can support it.
Thank you, Minister. That seems self-explanatory. Members, happy? Thank you. Deputy Bruton. Okay. So, Section 32. Amendment number 2. That the amendment be made. Thank you. Agreed? Agreed. Amendment number 3. That the amendment be made. Already discussed with 2. That the amendment be made. Agreed? Agreed. And amendment number 4, already discussed with 2, that the amendment be made. Agreed? Agreed. So that section 32 as amended stand part of the bill. Is that agreed? Agreed. Thank you. Section 33, no amendments. That section 33 stand part of the bill. Agreed. Section 34, that section 34 stand part of the bill. Agreed. Agreed. Section 35, that section 35 stand part of the bill. Agreed. Section 36, that section 36 stand part of the bill. Agreed. Section 37, that section 37 stand part of the bill. Agreed. If members, of course, wish to make any commentary on any of the sections, I'll take that. Section 38, that section 38 stand part of the bill. Agreed. Section 39, that section 39 stand part of the bill. Agreed. Section 40, that section 40 stand part of the bill. Agreed. Agreed. Section 41, that section 41 stand part of the bill. Agreed. Section 42, that section 42 stand part of the bill. Agreed. Agreed. Section 43, that section 43 stand part of the bill. Agreed. Section 44, that section 44 stand part of the bill. Agreed. Section 45, that section 45 stand part of the bill. Agreed. Section 46, that section 46 stand part of the bill. Agreed. Section 47, that section 47 stand part of the bill. Agreed. Section 48, that section 48 stand part of the bill. Agreed. Section 49, that section 49 stand part of the bill. Agreed. Section 50, that section 50 stand part of the bill. Agreed. Agreed. Section 51, That Section 51 stand part of the bill. Agreed. Agreed. Section 52, that Section 52 stand part of the bill. Agreed. Section 53, that Section 53 stand part of the bill. Agreed. Section 54, that Section 54 stand part of the bill. Agreed. Agreed. Section 55, that Section 55 stand part of the bill. Agreed. Section 56, that Section 56 stand part of the bill. Agreed. Agreed. Section 57, that Section 57 stand part of the bill. Agreed. Section 58, that Section 58 stand part of the bill. Agreed. Section 59, that Section 59 stand part of the bill. Agreed. Section 60, that Section 60 stand part of the bill. Agreed. Section 61, that Section 61 stand part of the bill. Agreed. Section 62, that Section 62 stand part of the bill. Agreed. Section 63, Amendment number 5 in the name of Minister. Minister to move.
Yeah, so this is the section, part 8, which is offences and penalties, and the first one of those is section 63. So we're just this is a minor drafting amendment to clarify that the reference to conviction in this section is to a conviction by a court-martial. The revised text is in line with the wording used elsewhere in the bill. For example, the reference to conviction by court-martial in section 65(2) of the bill. So this is essentially for clarity purposes, so there's no misunderstanding that this is not a conviction outside of the military system that we're referring to in the legislation. It's a conviction by court-martial.
Thank you, Minister. That the amendment be made. The Minister has moved. Agreed. Agreed. So that Section 63 as amended stand part of the bill. Agreed. Agreed. Section 64, that Section 64 stand part of the bill. Agreed. Section 65, that Section 65 stand part of the bill. Agreed. Agreed. Section 66, that Section 66 stand part of the bill. Agreed. Agreed. Section 67, that Section 67 stand part of the bill. Agreed. Agreed. Section 68, that Section 68 stand part of the bill. Agreed. Agreed. Section 69, that Section 69 stand part of the bill. Agreed. Agreed. Section 70, that Section 70 stand part of the bill. Agreed? Agreed. Section 71, that Section 71 stand part of the bill. Agreed? Agreed. Section 72, that Section 72 stand part of the bill. Agreed? Agreed. Section 73, that Section 73 stand part of the bill. Agreed? Agreed. Section 74, that Section 74 stand part of the bill. Agreed? Agreed. Section 75, that Section 75 stand part of the bill. Agreed? Agreed. Section 76, that Section 76 stand part of the bill. Agreed? Agreed. Section 77, that Section 77 stand part of the bill. Agreed? Agreed. Section 78, that Section 78 stand part of the bill. Agreed? Agreed. Section 79, that Section 79 stand part of the bill. Agreed? Agreed. Section 80, that Section 80 stand part of the bill. Agreed? Agreed. Section 81, Amendment number 6 in the name of the Minister, a new section. Minister to move.
Yeah, thank you. So this is on the end of page 61 of the bill, and it's adding a new section under the Service of Notices section, which relates to a code of practice. So this amendment inserts a new section into the bill to provide that the Provost Marshal shall, as soon as practical after the commencement of this section, prepare a code of practice to provide practical guidance to members of the military police in relation to the taking of samples for DNA testing under this bill. The code of practice will be prepared following consultation with Forensic Science Ireland. There's a similar provision in the Criminal Justice Forensic Evidence and DNA Database System Act 2014, under which a number of bodies, e.g. An Garda Síochána, the Garda Síochána Ombudsman's Commission and the Director General of the Irish Prison Service are authorised to prepare codes of practice. This is a minor amendment, but it will be useful in terms of ensuring that clear practical guidance is provided to members of the military police in relation to their functions under this bill, in relation to the taking of samples. It will also help to ensure a consistency in approach between this legislation and the Act of 2014. So what I'd say is, this has been done before. I think it'll be more straightforward actually to put this code of practice in place, because there's already codes of practice in place for the other bodies that I've mentioned, and I think it's good practice. So I I propose
Thank
that we
you.
accept it.
Thank you, Minister. Deputy Brady.
No, thanks, Chair, and thanks, Minister. Just a couple of small points in relation to, I welcome a code of practice, and I suppose just in relation to any conversations or the discussions you've had with the representative bodies from the Defence Force. I note that as this code of practice is put together, there will be conversations. So really just to see what discussions have taken place, if any, with the representative bodies, PD4 or RACO, in drafting this amendment. And of course, a code of practice and all of this legislation is only as important as the people on the ground to enact it. So maybe at this point you might just give us assurances that, given the major difficulties within the Defence Force retention and recruitment, etc., that there are adequate resources and personnel within military police to ensure that this legislation, which has been a long time coming, it has to be said, will be able to put into effect. Thanks, Chair.
Okay.
Sir, thank you.
Yeah, no, thanks. That's a very fair question. So what will happen once this legislation is passed and then commenced is that a code of practice will be prepared under this section, and then it has to be submitted to me as the Minister for approval. So we will obviously make sure that it's consistent with other codes of practice. I expect there will be consultation on that as well to make sure that consistency is there. The main source of guidance here will be FSI, because they are effectively the lead body in relation to DNA testing in terms of how it needs to be done and so on. The legislation is quite clear as well in terms of what's acceptable and what's not, and for what offences and not. Obviously it makes a clear distinction between taking DNA samples and taking intimate DNA samples, where one may be required, the other is essentially voluntary. So there's quite a lot in the legislation already. I mean, it's a long piece of legislation for a relatively straightforward concept. So there's a lot in it, and a lot of that is about consistency with what's already taking place, primarily within Garda Síochána. But just to give you a bit of reassurance, I have to sign off on the code of practice before it takes effect. So that'll give an opportunity for some consultation as well with the rep bodies.
Okay, thank you, Minister. Members happy? So section 81, that the new section be there inserted? Agreed? Agreed. And therefore that section 81 stand part of the bill? Agreed? Agreed. Moving on, section 82, that section 82 stand part of the bill? Agreed? Agreed. Section 83, that section 83 stand part of the bill? Agreed? Agreed. Section 84, that section 84 stand part of the bill? Agreed? Agreed. Section 85, that section 85 stand part of the bill? Agreed? Agreed. Section 86, that section 86 stand part of the bill? Agreed? Agreed. Section 87, that section 87 stand part of the bill? Agreed? Agreed. Section 88, that section 88 stand part of the bill? Agreed? Agreed. Section 89, that section 89 stand part of the bill? Agreed. Section 90, that section 90 stand part of the bill? Agreed? Agreed. Section 91, that section 91 stand part of the bill? Agreed. Section 92, that section 92 stand part of the bill? Agreed? Agreed. Section 93, that section 93 stand part of the bill? Agreed? Agreed. Title. Moving on to the title of the bill. So, have we agreement that this be the title to the bill? An act to amend the law to authorise the taking of bodily samples from military persons suspected of certain offences under military law for forensic testing, to provide for the taking of certain bodily samples from military persons or other persons who volunteer to have such samples taken from them for the purpose of investigation of offences or incidents that may have involved the commission of offences under military law, to provide for the establishment and operation by Forensic Science Ireland of the Department of Justice and Equality of a DNA military police database system, to provide for the purposes of that system, to provide for the taking of certain bodily samples from persons suspected of certain offences under military law for the purpose of generating DNA profiles in respect of those persons to be entered in the DNA military police database system, to provide for the taking of certain bodily samples from certain persons for elimination purposes, and where appropriate the entry of their DNA profiles in the DNA military police database system, to provide for the taking of bodily samples from military persons or samples from things for the purposes of generating DNA profiles to be entered in the DNA military police database system, to provide for the collection and analysis of other evidence, to provide in certain circumstances for the destruction of evidence and samples taken under this Act, and the destruction or removal from the DNA military police database system of any DNA profiles generated from these samples, to amend the Defence Act 1954, the Courts Martial Appeals Act 1983, the Criminal Justice Forensic Evidence and DNA Database Systems 2014, and to provide for related matters. Is that agreed? Agreed. This is concluding our consideration of the bill. Maybe Minister would like a word at this stage, or members? If not,
well, let me just say thank you for a very efficient consideration. The only amendments effectively were technical ones that we got advice from the Parliamentary Council on. To try and improve the bill to make sure that there's absolute consistency with the 2014 legislation which applies to the criminal justice system, and there'll be an opportunity for final consideration obviously at report stage, but I think it's a good piece of legislation. We did listen carefully at second stage as well. I mean, no party I think has an issue with it. This is about ensuring that there are appropriate mechanisms to investigate crimes within the military system, and I think DNA samples is a major part now of the justice system, and securing convictions in the appropriate way, and I think that has to go for the military court martial system just as it does outside of the military system. So I think this is a good piece of legislation. It's a relatively straightforward concept, even though it looks like quite a long complex piece of legislation, but I think by and large this bill mirrors the Criminal Justice Forensic Evidence and DNA Database System Act 2014, and that's what I think all the changes that we've introduced, and there was only 6 of them. It's about ensuring consistency between those two pieces of legislation. So I just want to thank colleagues for that, and I look forward to hopefully getting this legislation into law before the summer recess.
Okay, thank you, Minister. Thank you.
No, thanks, Chair, and thanks, Minister.
Be ready.
And no, look, I mean, we've no major difficulties with this legislation. It is, as you stated there, it's about bringing best practice into collection of evidence within the Defence Forces. I mean, there are other concerns there that we need to ensure that military law is brought up to the same standard as civil law, and maybe if it's allowable, you might give us an update there, because I know there is no set period to cover arrests or detention periods within the Defence Forces, and that is an issue of concern, and there's no stipulation in relation to the extension of arrest periods either, and who has the authority to extend those periods. And that is a cause of concern, Minister. I believe there was a piece of work being worked on in terms of amendments to the Defence Act. So if it's important that the evidence, the collection of evidence and use of DNA is dealt with, but that's also a critical piece of work that's needed to ensure that there are clear lines in terms of who has the powers, the periods of detention, etc. So that's on that. And again, Minister, through the chair, of allowable, it's not very often we get you before the committee here to discuss defence-related matters. So you might just take the opportunity to give us an update on the Commission on the future of the Defence Forces report, when you might be bringing forward an update in terms of the government response to the report. Was there's a lot of conversations there in the media, etc., about our neutrality and what that means and what potentially it may mean into the future. I think it would be useful to get an insight or an update as to the ongoing work in terms of disseminating the report and formulating a review, so that we can have that conversation and debate moving forward in terms of what the Defence Forces looks like into the future. Thanks, sir.
Thank you. I'm not going to open up a debate. We've had a 90-section bill just considered, and the Minister is here for that purpose. However, the Minister has always been generous with his time and indeed with his content here. So I am going to allow him perhaps give brief consideration to Deputy Brady's question, notwithstanding it's out of order. But Minister, brief. Thank you.
Yeah.
I'm sure the Minister won't object.
I'm happy to answer those questions. Given how efficient the committee was in terms of moving through the bill, we've got a few minutes anyway. Just on your first question, because the bill provides for significant enhancement of the powers of the military police in relation to the collection of evidence to assist their investigations. However, it wasn't possible to address all issues relating to the power of the military police in this piece of legislation. As regards powers of arrest and detention, the current legislative provisions are set out in Section 171 of the Defence Act 1954. This provides that a person subject to military law who is is found committing, is suspected of being about to commit, or is suspected of or changed under this Act with having committed an offence against military law, may be placed under arrest. The military authorities have examined the regulatory provision in the Defence Acts and regulations made thereunder relating to the military police, especially the powers of arrest and detention of persons subject to military law. The issues arising from that review with the military authorities are currently being considered within the department. However, this process is likely to take some time in view of the complexity of the subject matter. In that regard, there will be a requirement to carefully examine all relevant matters, including issues relating to powers of arrest and detention and the appropriate checks, balances and oversight requirements having regard to the equivalent legislation relating to Garda Síochána, which is the Criminal Justice Act 1984. In advance of any extension of the current military police powers of arrest and detention, detailed consideration will have to be given to the checks and balances that have been incorporated into the criminal justice legislation in relation to persons that have been arrested and detained, and whether and how these provisions should be provided for in defence legislation. In addition to the Law Reform Commission, as part of its fifth programme of law reform, is carrying out a review of the existing legislative provisions regulating detention in Garda custody. Any findings arising from the Law Reform Commission will have to be considered in the context of any update of military police legislation, including how those findings are reflected in civil law. There'll also be a requirement to obtain detailed advice from the Attorney-General before proceeding with any proposed legislation or regulatory changes. So, in other words, we are looking at this issue, but there are a number of other things that are happening in parallel that may inform the conclusions we draw. But it's a civil military discussion, to be honest, and I suspect we will be introducing some new legislation in that regard, but probably not until the back end of the year, maybe. But we'll have to. I don't want to put a timeline on it specifically, but there are some issues there that you raise. In relation to the Commission on the Defence Forces, yeah, so there's a lot of work going on in relation to this. I've said that I want to bring a paper to government responding to that Commission report in June, and that is what we're going to try to do. There are 69 key recommendations in that report. There's about 130 sort of recommendations, if you look at sort of sub-recommendations and so on, I think the context within which we're considering this has also changed. In relation to the war in Ukraine, I mean, every country in the European Union is now looking again at defence provision and security issues. I don't think we should have a knee-jerk reaction in that regard, but I certainly think we are living in a far more unpredictable and unstable security environment, not just on this continent but globally, and I think we need to respond to that. So from my focus is on ensuring that the evidence base that has been put in front of us in this Commission report, which I believe is a really good piece of work, by the way, can be a very solid basis for making those decisions. But all of the asks in the Commission report, or at least the vast majority of them, do cost money. And so I need to consult with party leaders and with other ministers in government to be able to ensure that what I bring to government is something that's supported. So there'll be a lot of work on that over the next 6 or 8 weeks before we actually bring a report to government. And obviously then once it's brought to government, it'll be, I hope, debated in this committee or discussed in this committee and in the Dáil and Seanad. But the Chief of Staff and his team and my Secretary General and her team are really working in quite an intensive way to make sure that we can bring that forward. The recommendation of the report is clear, that staying at the current level of ambition in terms of defence and defence provision in Ireland is not credible in terms of what we're asking of our defence forces versus the resourcing that we provide for them in terms of capacity, and that needs to change. And one of the reasons why I wanted to be a Minister for Defence again was because I wanted to correct that imbalance as Minister, and now we have an independent evidence base on the back of 13 months of work by the Commission to strengthen that argument. So, I think that we have had decades of underinvestment in defence infrastructure in Ireland by consecutive governments that goes right back to the to the 70s, and we need to correct that. We can't do it overnight, and even if we could do it financially overnight, the defence forces wouldn't be able to respond to a dramatic increase in financial resourcing in 1 or 2 years, because of course the most important element of the defence forces is human resources. And even if we move to level of ambition 2, which is what the Commission report recommends, that's recommending an extra 2,000 people in the defence forces, and that's the permanent defence forces, as well as significantly increasing the numbers in the reserve as well. And given the fact that we are 1,000 people below where we should be today, that's effectively an ask of increasing our defence forces, our permanent defence forces, by 3,000 people. And even if we were to add 500 people net extra each year into our defence forces, it would take us 6 years to get there. And we have never been able to add 500 people net into our defence forces in a 12-month period. So these are huge challenges, and that's just in terms of human resource recruitment and retention challenges, not to mention the actual structural change that's proposed within this report as well. So this is the Commission report is very demanding of government. It really does shine a light on defence, I think, in a way that we haven't seen before in terms of independent evidence base around exposing the lack of capacity in certain areas. And that's not news to me, but it is now, I think, hopefully going to allow me to make a very strong case to government that we need to correct it, and we need to set in train an investment programme that increases defence budgets for a multi-annual period of time to get us to a more credible space in terms of defence. We have fantastic personnel in our defence forces. We have great training programmes. We're really good at what we do in terms of peacekeeping in particular, and also many of the tasks that we perform here at home, at sea, on land and in the air. But there is a resourcing issue. Ireland is an outlier. There's just no question about that now. And, you know, we have in this report now a very clear series of numbers that shows that Ireland has fallen way behind our peer countries in the EU. Some militarily non-aligned, some neutral, some NATO member states. It's a series of different countries. We spend, on average, about a third of what other countries spend on defence, of similar size to us. That in GDP terms is about 0.3% of GDP. If you take GNI plus, which is often used, it's about 0.5%. But if you measure it in terms of a percentage of our overall budget, or if you measure it as a spend per capita in Ireland, all of those numbers are in the Commission report and the annex. And you know, regardless of what metric you use, we're spending about a third of what other countries are spending, and all of those other countries are now talking about the need to spend more. And if you look at what's recommended, what the Commission report is recommending is not a militarisation of Ireland or anything like that. It's simply to move from spending about a third of what other countries spend to spending about half of what other countries spend. We'd still be a significant outlier in terms of spend and capacity. Obviously, if we were to move beyond level of ambition 2 to level of ambition 3, well then that's a different prospect, but it's a very complex one to actually address because the Commission doesn't go into the detail of what that resourcing would fund. It does some of it, but not that much of it. So that's the work that's ongoing at the moment. As I say, this is a very demanding report of government. It's also very demanding of the Defence Forces themselves. In terms of cultural change, structural change, leadership change, in terms of how the Defence Forces operate, and of course the Department of Defence too, is really challenged by this report in terms of the interaction between civil and military management and everything from the accounting officer role to resourcing, recruitment, retention, cultural change, and a whole range of other things. So it's a really important piece of work. I think the Commission on the Future Defence Forces is the most important document on defence that we've seen in 50 years in Ireland, as long as we act on it. I've given, and I'm going to Baldonnel later on this afternoon. I've been to Collins Barracks in Cork. I've been to Hall Bolan. I've been to Carlbrua Barracks. And I am essentially visiting all of the barracks around the country to speak face to face with our Defence Force personnel to talk about their ambitions for the future, their views of the Commission report, and how we can collectively respond to it. And I'll continue that over the next few weeks because this is not essentially the department or the minister dictating to the Defence Forces. This is very much a partnership between the Defence Forces and government and the Department of Defence to bring about quite fundamental change. I really do look forward to bringing it to government and hopefully getting the support of my colleagues and other parties in opposition as well, because this is going to impact on defence for the next 20 years. And there will be different governments in that period of time. And what we need is actually a consistency of approach, if possible, from parties that lead and are part of governments in the future, so that the Defence Forces have clarity in terms of what's being asked of them and clarity in terms of how that's going to be resourced. So I will be trying to bring on board everybody who wants to be part of the action plan on the back of this report, to make sure that it's consistent, it's credible, and it's ambitious.
Okay, thank you, Minister. I would remind members that there is a further report in respect of the Defence Forces to which we will be required to give some attention, dealing with overseas duty. So what I would like to do is get a date over the next few days that we can chart a calendar for dealing with that, and then we'll be back to the Commission. And I feel members will agree that perhaps it's best to deal with these issues by way of joint committee meeting rather than in this more select form. But in any event, I was pleased that Deputy Brady posed his question and the Minister responded. So I think we're nearing completion. Just for the avoidance of any doubt, I take it I asked for agreement on the long title. I did. Yeah, good. That's agreed. Done. So as we've now considered the bill and as our consideration has been completed in accordance with Standing Order 101, the following message will be sent to the Clerk of the Dáil. The Select Committee on Foreign Affairs and Defence has completed its consideration of the Defence Forces Evidence Bill 2019 and has made amendments thereto. And I again thank the Minister and his officials for their attendance here this morning. And I now put that we adjourn. The Select Committee is adjourned sine die. Agreed, agreed. And thank you. And thank you.